lordship would stop the order passed by DRT, and that's a bi-party order, my lord. Bank is appearing before Honorable DRT. I am appearing before DRT. Matter has been heard.
Collector Tehsildar Bhind shall not proceed for taking possession in respect of the property of petitioner situated at Bhind because it is not a mortgage property as submitted.
DRT sometimes passes an order which one has to go to DRT and deposit and then take the hearing, my lord.
My lord, in this matter, in fact, my learned friend Mr. Satish Agrawal and my learned friend Mr. Shreyaraj Saxena, my lord,
Yes.
they are here to assist your lordship, my lord.
Yes.
My lord, may kindly, my lord, I'll not take much of your precious time, but my lord, I'll simply point out the various statutory provisions, my lord, which are brutally violated, and how the issue is pending consideration. And
Mr.
simultaneously, my lord, the respondent bank is proceeding further to mortgage the property. Ji.
Admittedly, your essay is pending before the DRT.
My lord, may I submit one thing, my lord? Your lordship, kindly permit me to refer few documents only, my lord. I'll not take much of your lordship's time, my lord. Your lordship,
Once it's pending before DRT.
my lord, what I am respectfully submitting, my essay has been finally decided by the DRT Jabalpur, against which we have preferred appeal before the DRT at Allahabad. Now, my lord, that appeal was heard only on the point of waiver of amount, my lord, waiver of payment. But it has not been heard on merits, my lord. That appeal is reserved for orders by the DRT, my lord. Now, my lord, simultaneously, what the respondent bank has done, it has again issued the sale notice and fixed the date of auction as 25th of November 2025. Now, my lord, if that auction is allowed to take place, it will, my lord, my entire case on merits would certainly fall down, my lord. Therefore, your lordship may kindly permit me to refer few important points, my lord, why we have approached this honorable court. Your lordship may kindly permit me to take your lordship to a few important aspects of the case.
One clarification before that.
Ji,
Para 3 in your petition,
ji,
that matter is pending before DRT.
ji.
But the 3 says something different. May I clarify, my lord, if lordship permits? What had happened, my lord? There were 2 rounds of red petition, securitization applications already before the recovery tribunal. My first essay was dismissed on the ground that this is barred by limitation. But a liberty was given that I can challenge the auction by filing a separate essay. I filed a separate.
No, your lordship, I'll request my learned friend,
I'm
Mr.
just coming
Akhtar,
to that. Look, I filed a separate essay that got dismissed on 10th of July this year, my lord, against which I have filed an appeal before Honorable DRT, which my friend Mr. Prashant Singh is referring. DRT has heard my waiver application and has reserved it for judgment on 6th of October. If your lordship sees page 253, your lordship would spot the order passed by DRT, and that's a bi-party order, my lord. Bank is appearing before Honorable DRT. I am appearing before DRT. Matter has been heard, and Section 13 to notice, possession notice, earlier option, everything is subject matter of challenge before Honorable DRT. And once that has been heard finally, my lord, and it has been reserved for judgment on 6th of October, on 16th of October, they published the auction, my lord. And at the top of it, when I go and file the fresh essay, my lord, against that auction, the learned registrar says, water sheet diziyega. When I inform to the registrar, my auction is on 25th, he gives me date of 17th of December, my lord. And bank takes thrice time to file reply to that essay, my lord. Kindly see this order sheet, my lord, for a moment. 17 December की तारीख, my lord. And I was there before your lordship a week before, my lord. Your lordship was pleased to fix the date, my lord, prior to the date of auction, my lord. That is 13th of November. Can your lordship be, look, that matter was not even fixed on 13. That was taken on 17 only by DRT. I have brought the orders, cause list of on that occasion, and fortunately, my friend Mr. Guru was only appearing that day, my lord. And your lordship passed an order. Now, can we see the last order sheet of this matter, my lord? 17th of December. Prior to that, twice bank has taken time for filing reply. And on 17th of November, also bank's time takes time for filing reply. Matter is urgent to 17th of December, 17th of December, my lord. DRT is already seized of the whole issue. reserved for orders. What is so hurry, my lord? Why do they want me to knock me down without even, my lord, kindly appreciate, under Securitization Act, your lordship has heard a lot of matters, my lord. As it is, the scope of audience and interference, even by the DRT, is extremely, extremely, extremely limited, my lord. 13.2 is given, representation is submitted. Against the decision, one cannot go to DRT. One can go to DRT only and only after possession is done. And that too, my lord, DRT sometimes passes an order which one has to go to DRT and deposit and then take the hearing, my lord. I have done such thing, my lord. I am there before DRT. DRT has heard me and because DRT has found a case, my lord. What is that case? I am not asking your lordships to go into the merits of that case, my lord. After
May I request my learned friend, Mr. Agarwal, your lordship may kindly appreciate, my lord, if your lordship will permit us. My lord, I am simply making a request, my lord. We'll point out some important dates, my lord.
Yes.
We'll place the chronology of the matter before your lordship, my lord. It will make the entire things clear.
Yes,
And why your lordship may kindly first permit me to take your lordship to page 35 of the writ petition. Now let us see what is the prayer which we are making in this writ petition. Let us see for a while. Page 35. My lord may kindly see page 35. At the bottom of this page, the request is made, my lord, to direct learned presiding officer of DRT Allahabad to hear the matter. That is SA number 1082 of 2025 urgently. Now, why this prayer is made? For two reasons. The learned presiding officer of DRT Jabalpur retired on 20th of September 2025, and there is an interim arrangement made by Annexure P20. My lord may kindly come to page 305 of the writ petition. Why this relief we are seeking, my lord? Page 305 of the writ petition.
yes.
Now, this is the interim arrangement which is made by the notification which was issued on 20th of September 2025. Your lordship got this notification at page 305?
Yes, 305.
Yeah. Now, my lord may kindly see, the advocates, litigants and all concerned are hereby informed that the Honorable Presiding Officer DRT Allahabad will hear the cases sale, possession and withdrawal matter pertaining to DRT Jabalpur through virtual mode. Now, my lord, time may kindly be seen from 2 p.m. to 3 p.m. only for 1 hour, with effect from 22nd of September 2025 onward. So, my lord, PO DRT Allahabad is already overburdened by making this kind of temporary arrangement. Therefore, my lord, we claim this relief that the learned PO of DRT Allahabad may be directed to decide the SA 1082/2025 urgently before proceeding further with the sale notice which was issued on 16th of October 2025. Now, my lord may kindly see the interim relief that your lordship will find at next page, my lord, 36. We are seeking interim relief. Kindly stay the auction scheduled on 25th of November 2025 until decision in SA number 1082 of 2025 is fetched. Now, my lord, your lordship may kindly permit me to refer few important things what my learned friend Mr. Satish Agarwal was mentioning. My lord, I'll just mention, my lord, initially what has happened in this case.
Yes.
Annexure P1, my lord, I'll point out only few annexures. Annexure P1 dated 26th of June 2015. Now, this was the initial demand notice which was issued under section 13.2. This document your lordship will find at page number 44.
Yes.
Now, my lord, I'll refer only few documents. Now, my lord, this was the initial demand notice which was issued by them, raising demand of deposit of rupees 35.34 crores as it was prevailing on 26th of June 2015. Now, subsequent to this, my lord, they have taken over symbolic possession on 19th of September 2015, and that your lordship will find from annexure P3 at page 49. My lord may kindly see P3, page 49.
Yes.
My lord may kindly see the last paragraph. This is the, my lord, all other facts and figures P3 at page 49, my lord.
Yes.
I'm sorry, my lord. Your lordship may kindly first come to annexure P2 at page 47. Now, this is the possession notice, my lord, which was published on two newspapers, Annexure P2 at page 58 and page 47 and 48. This is dated 22nd of September 2015. Then, my lord, may kindly come to Annexure P3. Now, this is the most surprising step which has been taken by the respondent bank. My lord, may kindly take note of this demand notice. Annexure P3, dated 15th of June 2015. What the bank is writing, we refer, my lord, under the heading of this application notice under section 13.2, we refer to our section 13.2 notice annexure P1 dated 26/6/2015 at page number 1 para 2 regarding securities asset. It is inadvertently mentioned as, and then, my lord, the demand notice which was issued as annexure P1 was modified by annexure P3. Now, my lord, your lordship may kindly take one legal argument which I will place for consideration before your lordship. That initially, my lord, demand notice was issued on 26/6/2015 annexure P1, and this demand notice was modified on 15th of June 2016 annexure P3. My first legal argument is this demand notice cannot be modified unless and until petitioner makes a representation or raises some objection, and this is grossly in violation to Rule 13. My lord, may kindly permit me to refer the rule, my lord.
Yes.
How this is violated. My lord, may kindly permit me to take your lordship to the relevant Rule 3(3)(a) for a while, my lord. What is mentioned here?
Rule 3(3).
Demand notice, my lord. Rule 3.
Yes.
My lord, may kindly come to Rule 3(A). Rule 3, sub-rule. No, I'm sorry, my lord. Rule 3(a), the amended provision of Rule 3(A).
Can I pass it on, my lord, for convenience to your lordship? Please pass it on to the.
My lord, only in one eventuality, the demand notice can be modified. Now, this is the legal argument I'm placing for consideration of your lordship. Under what kind of circumstances, my lord, the demand notice can be modified? Now, this Rule 3(a), sub-rule B deals with that. If on examining the representation made or objection raised by the borrower, the secured creditor is satisfied that there is a need to make any changes or modifications in the demand notice, he shall modify the notice accordingly and serve a revised notice or pass such other suitable orders as deemed necessary within 15 days from the date of receipt of the representation or objection. Now, my lord, may kindly take note of this important fact. We have not raised any objection. We have not made any representation against the demand notice dated 26/6/2015 annexure P1. Still then, my lord, they have overlooked this statutory provision. They modified it. Now, my lord, may kindly see.
Yes.
Then, my lord, may kindly see. Here, my lord, they have published sale notice on 16th of July 2016. Annexure P4 is there. Page 50. My lord, this chronology is important, my lord. Then only I'll be in a position to satisfy your lordship on the legal issue. Now, my lord, annexure P4 at page 50. Now, this is the sale notice by which, my lord, date of auction is fixed as 22nd of June 2016. Now, I have referred annexure P1, P2, P3, and P4. I have also mentioned, my lord, about the statutory violations. Then, my lord, what we did, we filed. Now, my lord, there are 3 essays. Therefore, my lord, I am mentioning the first essay which I filed. My lord, I filed first essay number 223 of 2016. This is the first essay.
Yes.
Now, this is the first essay which we have filed before DRT Jabalpur on 4th of August 2016. Now, date is important, my lord. And this essay, memo of essay, is there on record as annexure P10 at page 108.
Yes.
This was the first essay. Now, in this essay, I have challenged annexure P1, annexure P2, P3, and annexure P4. Now, my lord, on the date of auction, which was fixed as 22nd of June 2016, the respondent bank failed to receive any bid, my lord. So in fact, that auction proceedings failed. Then, my lord, what they did on 31st of October 2019, they have issued fresh sale notice, by which, my lord, they have fixed the date of auction as 3rd of December 2019.
Yes.
Now, what we did, my lord, under section 17, there is a provision that we can make any application against measures to recover secured debts, my lord. So we moved an application under section 17 in essay number 223 of 2016 and challenged the auction proceedings which was scheduled for 3rd of December 2019. Now what has happened, my lord? This essay 223 of 2016 was dismissed, wide order dated 3rd of December 2019. Your lordship will find this dismissal order at annexure P9 at page 104. So my first essay, 223 of 2016, in which we have challenged annexure P1, P2, P3, P4, as also the auction which was scheduled on 3rd of December 2019, that essay was finally dismissed on 3rd of December 2019. My lord may kindly come to page 104 for a while.
Yes.
Just for a while, my lord, I'll not take your lordship deep into the merits of the case. But the illegalities, my lord, which they have committed,
Yes.
I need to point out those illegalities. My lord may kindly come to page 104, and I request your lordships to kindly come to page 107, the operative part of the order. How my essay, first essay 223 was dismissed. Last two paragraphs are important. The applicants have failed to come up with any material fact which prevented them from filing the present essay within the prescribed period of 45 days. And therefore, it has to be held that the application for condonation of delay lacks merits and substance and is accordingly dismissed. Then next paragraph is important. The essay is thus dismissed, being barred by limitation, as the main essay itself is being dismissed, the pending IS2 are dismissed. Now, this is important line, my lord. With liberty to the applicants to file fresh essay in any case, in case they so desire. So I conclude by saying my first essay was dismissed by holding that delay cannot be condoned, firstly. Secondly, liberty is granted to the petitioners to file fresh essay. So by this order, my lord, first essay 223 of 2016 was dismissed. Now, my lord, we resorted to two remedies. My lord, number one, what we did against, my lord, by taking a liberty which was granted by DRT Jabalpur, we have filed second essay. That essay number is essay number 700 of 2019. That your lordship will find as annexure P11 at page 109. This is the second essay. Essay number 700 oblique 2019. And simultaneously what we did, we also challenged the dismissal order of first essay before DRAT by filing MA number 75 of 2020. What DRAT did, DRAT dismissed our appeal against dismissal of first essay on 16th of October 2020. Your lordship may kindly refer this order, annexure P10 at page 108. Page 108.
Yes.
So, my lord, this is the MA which was filed against dismissal of first essay 223 of 2016. Now, let us see what appellate tribunal is writing. Reply has been filed on behalf of the appellant. Heard the learned counsel for the parties on the recall application. Learned counsel for the recall applicant submits that the separate appeal filed by the recall applicant has been disposed of by separate order. In view thereof of the appellant does not want to press this recall application and would participate in the proceedings pending before the DRT in essay number 700 of 2019. This is second essay. Learned counsel for the non-applicant has no objection. Therefore, the recall application is disposed of as not pressed, no order is to post. So, my lord, we withdrew that and we pursued our remedy in essay number 700 of 2019. Then, my lord, what has happened, your lordship may kindly see, we argued this essay number 700 of 2019, my lord, which was, your lordship may kindly see, finally dismissed by the DRT Jabalpur, wide order dated 10/7/2025. So even second essay was also dismissed. The order your lordship will find at page 149, annexure P14. Second. Now, Malad, this second essay was dismissed. Date is important, on 10th of July 2025. Now, this is the second essay. Now, against this, my lord, we have, your lordship may kindly appreciate. In the meantime, what has happened, my lord, they have issued fresh sale notice dated 16/10/2025. This is again important, my lord. Sale notice.
Yes.
16/10/2025.
Yes.
And in which auction is fixed for 25/11/2025. Now, my lord, this we have challenged. This we have challenged before DRT Jabalpur in essay number 1082 of 2025. Now, this is the essay which is still pending for consideration before DRT Jabalpur. This is essay number 1082 of 2025. So this is my third essay. Now, my lord, one thing I would like to point out, how our second essay, 700 of 2019, was dealt with. Your lordship may kindly come to page 182 for a while.
Yes.
Yes. Now, my lord, may kindly see sub-para 4, top paragraph. उत्तरावादी बैंक को रोड हाईएट विंडर संजय इंगोले, प्रवीण हिब्राले एवं राहुल सोमानी से आगामी 15 कार्य दिवस के अंदर इनके द्वारा जमा बिड अमाउंट का 25% के अतिरिक्त शेष 75% बिड अमाउंट जमा कराकर उनके द्वारा क्रय किए गए प्लॉट नंबर इत्ता के विषय में सेल सर्टिफिकेट प्रदान किए जाने की स्वतंत्रता प्रदान की जाती है. The important point which is to be noted is, my lord, the learned the DRT Jabalpur granted, extended the time of submission of 75% of the bid amount, which is contrary to Rule 9. My lord, may kindly refer to Rule 9 for a while, man. Rule 9(4).
Rule 9(4).
4. Rule 9(4). Now, Rule 9(4) says, your lordship got this provision, man.
Yes, yes. 9(4).
The balance amount of purchase price payable shall be paid. Now, this is important one. The balance amount of purchase price payable shall be paid by the purchaser to the authorized officer on or before the 15th day of confirmation of sale of the immovable property, or such extended period as may be agreed upon in writing between the purchaser and the secured creditor. Now, last line is very important. In any case, not exceeding 3 months. So, my lord, this is the statutory provision. But then the learned DRT.
Extended for 6 years.
But,
Auction was 2019.
yes, the learned DRT, by passing the order dated 10th of July 2025, has extended this statutory period.
Yes.
By ignoring this important fact that there is no statutory power vested upon the learned DRT Jabalpur. So, my lord, all these important legal points are under consideration in essay number 1082 of 2025. Now, your lordship may kindly see, we did our best effort to pursue our remedy before learned DRT Jabalpur. But, my lord, they have not taken up, they have not assigned due seriousness in hearing the matter urgently, because they have said that some temporary arrangement is made. And
I'm sorry to interrupt.
Of
The dismissal of second essay we have carried to Honorable DRT. The dismissal of second essay we have carried to Honorable DRT, and Honorable DRT has heard the Lord on waiver and has reserved that order.
I'll just point out, my lord, that order I'll point out. So
that is a 243.
Ji. So then what has happened, my lord? This is the temporary arrangement which I pointed out, annexure P20 dated 20th of September. Now, my lord, only for 1 hour, learned PO Allahabad is hearing matters virtually. Now, what my learned friend Mr. Satish Agarwal has pointed out, we have preferred an appeal. That appeal is yet to be heard by the DRT, my lord. What DRT has heard us only on the question of waiver of amount and reserve it for order. That order your lordship will find. Your lordship will find that order
Page 243.
at page 243. My lord, may kindly have a reference to this order.
Yes.
243. My learned friend Mr. Satish Agarwal appeared before DRT. Even his presence is recorded. Last two lines. Heard the learned counsel for the parties on the waiver of application. Then last line, order reserved. So now what has happened, my lord? Against dismissal of second essay, our DRT appeal is pending before DRT Jabalpur. That appeal has yet to be heard on its merits. That appeal is yet to be heard on the serious statutory violations. But it is reserved for orders only on the point of waiver of amount. Our fresh essay, which is number 1082 of 2025, that is pending consideration before learned DRT Jabalpur. Now, your lordship may kindly see the order sheet of DRT Jabalpur. They are not taking up this matter, my lord, before the date of auction on 25th of November 2025. Yes. They have fixed next date of hearing as 17/12/2025. 17/12/2025. My lord, the copy we will supply, my learned friend will supply that copy, my lord, to your lordship directly in the court. Now, what has happened, my lord? Your lordship may kindly appreciate only one thing, my lord, which is not related with the present case. But how I'm sorry to say, my lord, how the DRT Jabalpur is dealing with the directions issued by the Honorable Court. For that, my lord, I would like to take your lordship to page 303 for a while. This was the order in which my learned friend Mr. Satish Agarwal appeared in regard to some other party, my lord.
303.
303. How, my lord, the order of Honorable High Court, my lord, that is taken into consideration by the DR. Now, your lordship may kindly see. First paragraph, the instant petition is filed under Article 226 of the Constitution of India being aggrieved by the order passed by Registrar DRT Jabalpur directing to place the matter before DRT Allahabad on 17/11/2025 as the presiding officer in DRT Jabalpur is not available. He argued that the date for auction is fixed for 14/11/2025. This date is important. The Honorable Court was passing order on 11th of November 2025. Date of auction in that case was fixed as 14th of 11/2025, and the date for hearing has been fixed on 17th of November 2025. Taking all these things into consideration, my lord may kindly see para 5 of your lordship's order. Next page. Next page, my lord.
It's a C.
Ji.
Continue after lunch.
Ji. I'm so kind of you, my lord. I'll appear after lunch.
Yes. Yes, Mr. Singh.
Ji, I'm sorry. So, my lord, I was pointing out before lunch, my lord, how the orders of the Honorable, the direction given by the Honorable High Court
Yes.
are dealt with by the DRT, my lord. And for that, my lord, I invited your lordship's kind attention to page 303, annexure P19, in which your lordship took note of this important fact that the date of auction is fixed for 14th of November 2025. Therefore, your lordship was kind enough to pass this order on 11th of November 2025. In paragraph 5, it was directed that, my lord, may kindly see paragraph 5 at
Yes.
304. In view of no objection by counsel for the respondent, the present petition is disposed of with a direction to the Registrar DRT Jabalpur to place the case before DRT Allahabad on 13th of November 2025. So, my lord, a day prior to the date of auction is the date which was given by your lordship that matter be taken up for hearing. But my lord may kindly see, my lord, the few documents are supplied to your lordship on board, my lord.
The list of 17, it was placed before the DRT on 17th, originally fixed date not on 13th. The last page only your lordship may see, which my friend Mr. Singh is referring.
So, my lord, your lordship may kindly see the matter was not placed. Matter was not placed on 13th. It was placed after auction, my lord, which took place on 14th of November. The matter was placed for consideration on 17th of November 2025. So, my lord, this is the manner the DRT is proceeding. So, my lord, I conclude my submission, my lord, because before your lordship, my lord, I am not mentioning my submissions on the merits of the issue. But, my lord, the important issues which emerges before your lordship for kind consideration. Number one is, my lord, when the DRT is seized of the matter
Yes.
on merits and reserved it for orders merely on the point of waiver of payment, then it is lawful on the part of the respondent bank to proceed further with fresh auction notice to auction the mortgage property, my lord, because the whole case on merits would collapse. And that order, my lord, at page 243, my lord, the matter was reserved on the
Yes.
point of 243. The matter DRT seized of the issue on merit and has reserved it for orders only on the point of waiver of the payment. Now, second issue for consideration before your lordship is, my lord, in the relief clause, we have clearly mentioned that we have raised challenge to the fresh auction proceedings initiated by the respondent bank in essay number 1082 of 2025 and DRT Jabalpur is in consideration of this matter, and despite our urgent applications, my lord, they have fixed this case for hearing after auction on 17th of December 2025. Whether non-hearing of interim application for grant of estate amounts to refusal to grant interim relief, causing serious injustice and prejudices to the petitioner. Now, my lord, all these legal issues are there before your lordship's kind consideration. Now, my lord, I would request my learned friend Mr. Shairaj Saxena, is present in the court, to supply the bunch of judgments, my lord, on which I am placing the line.
Yes.
So, my lord, your lordship may kindly,
Yes.
I just point out, my lord, what is the consistent view of our honorable court under almost similar circumstances, but maybe case arises out of different facts and circumstances. For that, your lordship may kindly come to page 1 of my compilation.
Yes.
Paragraph 2. He submits that on account of non-availability of the presiding officer in the Debts Recovery Tribunal, Jabalpur, the aforesaid alternate remedy is not efficacious, and hence he prayed for maintenance of the status quo till his application for interim relief is considered by the Debts Recovery Tribunal, Jabalpur. Then your lordship may kindly come to page 2 of the compilation. Para small Roman 5. The petitioner is directed to communicate this order to the Registrar DRT Jabalpur within 7 working days from today. If there is excessive delay at any stage of proceeding, including the appointment of presiding officer DRT Jabalpur, parties are free to approach to this court. It is made clear that we have not expressed any opinion on the merits of the case. Para 3 may kindly be seen, small para Roman 3:1. Till the
Yes.
application for interim stay in the said essay is decided by DRT, no coercive action be taken against the petitioner subject to compliance of direction number 1. My lord may kindly come to page 3 of the compilation. I'll read somewhere in the middle of paragraph number 2 so as to save the time of the honorable court. And that part starts from petitioners being borrowers are facing heat of execution, and for that an application under section 17 of the Surface Act of 2002 was preferred before the DRT Jabalpur, but in the absence of the presiding officer, it is not functioning at present. Therefore, matter was transferred to DRT Allahabad, but volume of work is pressing there. Then my lord may kindly come to page 4 of my compilation, para 10.
Yes.
As an your lordship will find at the bottom of page 4 of my compilation. As an interim measure till next date of hearing, the collector Tehsildar Bhind shall not proceed for taking possession in respect of the property of petitioner situated at Bhind because it is not a mortgage property as submitted. If the authorities find that it is a mortgage property, then they may proceed against the property also. For rest of the properties of the petitioner, the interim relief is not applicable. Then my lord may kindly come to page 7 of my compilation, my lord.
Yes.
The tribunal is not functioning at Jabalpur. Therefore, the petitioners have no other alternative efficacious remedy to seek interim protection except to file the present petition. It is urged that the till application for stay is considered by the tribunal, the interim protection may be granted by the court in support of this submission. He has placed reliance on the order passed by the coordinate bench of this court in the case of so-and-so, passed in writ petition number so-and-so, decided on 26th of April 2024. After hearing counsel for the parties without adverting into the merits of the case, the present petition is disposed of by directing the respondents to maintain status quo by both the parties in respect of property in question till securitization application filed by the petitioners at DRT Jabalpur is considered. Then my lord may kindly come to page 10. In
Yes.
this matter also, my lord, page 11, I'll just point out, my lord, because I'll save your lordship's time. Relief, no coercive action be taken against the petition by the bank state. With the aforesaid direction, petition stands disposed of. Then my lord will find one order at page 14, my lord, para 7.
Yes.
We are told that DRT is not functional in Madhya Pradesh. The litigant cannot be left remediless. We hence deem it proper to dispose of this writ petition by directing the petitioner to file an appropriate application along with a prayer for interim relief before the Debt Recovery Tribunal in respect of the action initiated by respondent number 2, which is the subject matter of this petition within a period of 30 days from today. In case such application is filed by the petitioner praying for interim relief, DRT shall take up the said application including the prayer for interim relief till it becomes functional and take a decision on the prayer for interim relief in accordance with law expeditiously. It shall be the duty of the petitioner to communicate this order to the respondents and to the registry of DRT within 7 working days from today, failing which interim protection shall cease to operate automatically. In the meanwhile, the respondents are restrained from taking any coercive action. Then my lord may kindly see the page 17, my lord, last paragraph. If the petitioner fulfills aforesaid direction till decision is taken, DRT on interim prayer of the petitioner, no coercive action shall be taken. And then my lord may kindly have a reference to one of the orders at page 21. And in that matter, my lord, the Honorable High Court kept the writ petition pending for final adjudication and granted interim relief. Your Lordship may kindly come to page 21 of my compilation. Then a counsel for the petitioner has appeared on behalf of the borrower and has submitted before this court that they have filed an essay before the DRT challenging the order passed under section 14 of the SARFAESI Act. He further submits that the presiding officer has retired and a new presiding officer is yet to be appointed at the DRT Jabalpur. And all the cases are now being heard at Allahabad, Uttar Pradesh. On account of inconvenience caused to the petitioners, they have prayed for unlimited relief till the next date of hearing, by which time, hopefully, the presiding officer to the DRT Jabalpur would also be appointed. Under the circumstances, issue notice to the respondents on payment of PF within 5 working days. Notice be made returnable in 3 weeks. Till the next date of hearing, the execution of section 14 order of the CJM bid shall remain stayed. The same shall also stand vacated if not extended by an order of this court on the next date of hearing. Then subsequently, my lord, this petition was withdrawn. Finally. Now, my lord may kindly appreciate, my lord, there are various judgments, my lord, whether under the given facts and circumstances, Honorable High Court can protect the interest of litigant so that, my lord, his case on merits may not fall. Because of the conduct of the respondent, my lord, in the case at hand, my lord, they have proceeded further with the auction proceeding. My lord may kindly come to page 22 of the compilation. Now, this is the division bench decision in the case of Alok Kumar Chobe,
Yes.
in which, my lord, the honorable court was kind enough to hold under what circumstances, my lord, the extraordinary writ jurisdiction under Article 226 of the Constitution of India can be invoked. Now, my lord may kindly permit me to take your lordship to paragraph 6. Your lordship will find at page 27 of the compilation. Paragraph 6, my lord. Dealing first of all the preliminary objection of the respondents that since the matter has got an efficacious, petitioner has got an efficacious alternative remedy in view of dispute resolution system provided under clause 12 of the agreement, the writ petition ought not to be entertained. What is to be seen is whether remedy can indeed said to be efficacious. The word efficacious is adjective according to grammar and its noun is efficacy, which is derived from Latin word efficacy, which means capacity to produce results. Accordingly, the word efficacious means able to produce the intended effect or result. The Guwahati High Court in the case of so-and-so held that it is well known that the meaning of the term efficacious is able to produce the intended result. The High Court negated the preliminary objection raised by the respondents with regard to maintainability of the writ petition, as its view was that the alternative remedy provided in that case was not likely to produce the intended result. Para 16 may kindly be referred, my lord, at page 34 of the
Yes.
compilation. 7 well-recognized exceptions to the rule of alternative remedy, which can be culled out from the afore discussed judgments of the Supreme Court for entertaining a writ petition under Article 226 or under Article 227 of the Constitution, can be summarized thus. Number 1, where the writ petition has been filed for enforcement of fundamental rights, where there has been violation of principles of natural justice, where the order of proceedings is wholly without jurisdiction, where the violence of any act is under challenge, where availing of alternative remedy subjects a person to very lengthy proceedings and unnecessary harassment. This is important, my lord. Then, where the writ petition can be entertained despite alternative remedy if the question raised is purely legal one, there being no dispute on facts. This is also important. Then, where a state or its intermediary in a contractual matter acts against the public good interest unjustly, unfairly, unreasonably, and arbitrarily, despite aforementioned noted exceptions, especially 5th and 7th of the above, whether or not in a particular case the writ should entertain a petition under Article 226 of the Constitution of India rather than requiring the petitioner to avail alternative remedy would always depend on the facts and situation of a given case, upon the petitioner making out a strong case. If it is shown that the facts of the case are not disputed and the government or its instrumentality has been found acting unjustly, unfairly, and unreasonably, even in regard to its contractual obligation, the High Court would be justified in entertaining the writ petition despite availability of alternative remedy. Para 17, in view of what has been discussed above, the question is no longer res integra. That is, so, my lord, what I am respectfully submitting is, in the given case, we have availed our remedy, my lord, on merit. The DRT is seized of the matter, heard
Yes.
only on the limited point of waiver of amount, my lord, and reserve it for order. Now, my lord, subsequently, again, auction proceedings are drawn. We have filed fresh essay. That is also, my lord, pending consideration. We have filed an application for urgent hearing. We have requested DRT to hear it before 25th of November 2025. They are not hearing it. They have posted this matter for 17th of December 2025. Now, my lord, may kindly come to page 46. This is a full bench decision, my lord, with regards to Madhya Pradesh Uच्च न्यायालय खंड न्यायपीठ को appeal अधिनियम 2005. There are some important issues which are discussed in this matter too. So, my lord, I'll refer only 3 paragraphs of this judgment, 26, 27, and 28.
Yes.
I directly request your lordships to kindly come to page 59 of my compilation, my lord. These 3 paragraphs, my lord, I'll just refer, my lord.
Yes.
So at page 59 of my compilation, my lord, paragraph 26, from the aforesaid enunciation of law, there remains no scintilla of doubt that interlocutory orders on certain circumstances could be appealed against under the letters patent. Despite the fact that they are interlocutory in nature, they can be put into the compartment of judgment. If it affects the merits of the case between the parties by determining some rights or liabilities, there can be 3 categories of judgment: final judgment, preliminary judgment, and intermediary judgment or interlocutory judgment. If the order finally decides the question and directly affects the decision in the main case,
Yes.
or an order which decides the collateral issue or the question which is not the subject matter of main case, of which determines the rights and obligations of the parties, in a final. My lord, all these judgments are, my lord, are aware of all these judgments. I am simply reminding your lordship, my lord.
The alternative remedy is not absolute bar. That we will consider, Mr. Singh.
Yeah, my lord, my only respectful submission is, my lord, now 25th of November is very close. So, my lord, let they may be directed, my lord, to come out with their reply on merits, my lord. Until then, my lord, auction proceedings may not be conducted. Otherwise, my lord, nothing would remain for adjudication by the DRT, Allahabad, my lord. And the DRT has already reserved the case for orders on a limited issue. Now, even DRT Jabalpur is not hearing, my lord, essay on the point of stay. So, under these special circumstances, my lord, I most humbly, my lord, invite your lordship's kind indulgence in this matter, my lord. I conclude by saying, my lord, that your lordship may kindly grant some protection to the petitioner, my lord. I am so highly obliged. Your lordship was
Make
afforded me a patient hearing. I am so
not more than so
highly
much.
obliged.
Very high. 9-2. Your lordship, no problem.
Mr. Singh, let us hear.
No, there is a legal issue, my lord, that in the event if sale is confirmed, then Supreme Court in case of Salar versus Sumati says, my lord, it cannot be reversed easily. So entire issue is that there is a provision in 9-2, my lord, that after the bid comes, my lord, the sale has to be confirmed. Where para 218, my lord, your lordship can read it, my lord. I'm just passing it on, my lord. We will read. Paragraph 218, my lord. Yes, master. Paragraph 218 in Sumati Prasad, my lord, Supreme Court says if sale is confirmed, which is in consonance with 9-2, my lord.
We are aware of that.
I'm grateful. I'm grateful.
We are-
I'm grateful.
Yes.
May
The
please, my
bank-
lord. My lord,
Yes.
appearing on behalf of the bank, my lord, the entire loan amount today stands in public money of 86 crore, my lord. And this is the third round of litigation before the DRT. First was SA 223/16, they lost the matter, my lord. Next is 1082, sorry, so next is 700 of 19, it was dismissed, my lord. And the appeal which they have filed, there is no stay order on that, my lord. Now the present SA is 1082/25, my lord.
Yes.
I am giving this undertaking that the reply will be filed by 5 p.m. today, my lord. The bank officer is present. And my lord have himself given the order in Narmada exclusion, my learned senior was there, that the matter may be placed on one day before, that is on Monday, my lord. And DRT may hear it, my lord. That was the consent which I consented and my learned senior was consented. My lord, if stay is granted on the auction proceeding, that will open floodgates of litigation, my lord, in this, because there have been several rounds of litigation and all these arguments have been considered by DRT when it was dismissed, my lord. Now, whatever has been filed with DRT, no stay order has been given. And the only amount and the only reason of this of the DRT is that whether they should pay the 25% penalty, the 25% court fees or not, money.
Not
That is-
please.
I apologize. 25% which needs to be paid, my lord. My lord, humble submission in this, my lord. We are ready to file the reply by 5 p.m. today, and matter may be kept on Monday. There should be no stay on auction proceeding, my lord. Humble submission. Deeply obliged, my lord.
We will pass them.
I'm grateful. Judge.
I'm deeply obliged, my lord. I'm deeply obliged.
My lord, one small submission. They may accept our reply. We'll also send it through email because there has been some problem, my lord.
No problem with me to accept.
No,
the reply.
some office problem that have been instructed by the bank just now.
Good, Vyati, you take 3 times, you take time.
Deeply obliged, my
Date
lord.
is gone to 17th of December.
No, not with
Now
you.
you are saying you'll give it
No,
to me
not
now.
with you, sir. Just the officer.
I'm deeply